Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad SHAFIE. My metric number is 076602. And today, I will briefly introduce our partnership agreement for the Daydream Bakery & Co. This partnership agreement was entered into by 8 partners on 3rd November 2025 in accordance with the Partnership Act 1961. The main purpose of this agreement is to clearly set out the rights, duties and responsibilities of each partner. It also covers important matters such as capital contribution, profit and loss sharing, management structure, decision-making powers and dispute resolution mechanism to ensure transparency and avoid conflicts among partners. The business involved is a bakery business operating under the name The Daydream Bakery & Co. located at Central ICT Shah Alam. The bakery focus is on the production, sale and distribution of baked goods such as bread, pastries, cakes and related food products. Our objective is to provide high quality bakery products, build a strong brand and achieve sustainable growth and profitability through effective partnership management. That's all from me. Thank you.
My name is GURMEET Singh. I'm 62 years old. Okay, now regarding dispute resolution, of course the governing law of this partnership agreement will be laws of Malaysia, including but not limited to the Partnership Act 1961. Now, it's very important to note that if there is any dispute, the partners shall first use their best endeavors to resolve the dispute amicably through good faith discussions, and if the dispute does not settle or it's not settled within 30 days, then the mediation process kicks in and the mediator, it will be conducted. Mediation will be conducted by a mediator appointed by the Malaysian Mediation Centre or any equivalent recognized party. Now, if even the mediation falls apart, the dispute is not settled within 60 days, then such dispute will finally be resolved through arbitration in accordance with the Arbitration Act, of course, Arbitration Act 2005, where such arbitration shall be conducted by an arbitrator who is appointed by mutual agreement, or if there is no mutual agreement, appointed by Asian International Arbitration Centre, AIAC, in Kuala Lumpur. And it's also very important to note that the arbitration award shall be final and binding on all partners and will be enforceable, of course, in any court of law. Now, last but not least, the rights under Partnership Act 1961. Nothing in this clause shall prejudice or restrict any rights or remedies available to the partners, including the right to seek dissolution of the partnership, of course, in accordance with the Partnership Act 1961. Thank you.
Assalamualaikum. My name is AQILAH binti MALIK, metric number 07445. Next, I will explain the clauses on the admission and withdrawal of a partner by referring to their purpose, legal significance, alignment with the Partnership Act 1961, and the reason why each clause was drafted in this manner. Firstly, the clause on admission consent requires unanimous approval from all existing partners before a new partner may be admitted. The purpose of this clause is to preserve mutual trust, as a partnership is a relationship based on confidence. Its legal significance is that it prevents any partner from unilaterally introducing a third party into the partnership. This clause aligns with Section 26G of the Partnership Act, which requires unanimous consent for the admission of a new partner unless otherwise agreed. It was drafted expressly to reflect the statutory rules and to avoid dispute over unauthorized admissions. Secondly, the requirement for a written partnership agreement reflects Section 21 of the Act, which allow partners to vary the default rules of the Act by agreement. The purpose of this clause is to give legal certainty to the right and obligation of partners. Its legal significance lies in ensuring that agreed variations such as profit sharing, withdrawal terms or expulsion are enforceable. The clause was drafted in writing to avoid ambiguity and evidentiary issues. Moving on to capital contribution and profits or loss sharing, the clause links ownership share to the contribution made by the partner. The purpose is to ensure fairness among partners. Legally, this clause modifies the default position under Section 26A, which provides for equal sharing of profits and losses unless otherwise agreed. This clause was drafted to lawfully depart from the statutory default and reflect commercial reality where contribution contribution may differ. Next, the clause on involuntary withdrawal or expulsion allows a partner to be removed only under specific circumstances. The purpose of this clause is to protect the partnership from misconduct or incapacity. Its legal significance is that it complies with Section 27 of the Act, which states that a partner may only be expelled by majority if the partnership agreement expressly provides for such power. This clause was carefully drafted to avoid unlawful expulsion. Regarding voluntary withdrawal, the clause requires advance written notice. The purpose is to ensure continuity of business operation. This aligns with Section 28 and 34, which regulate retirement by notice or expiration of partnership terms. The notice requirement was drafted to prevent sudden withdrawal that could prejudice remaining partners. In case of death or bankruptcy, the clause reflects Section 35 Clause 1, where such event may trigger dissolution. Unless otherwise agreed, the purpose of this clause is to provide clarity on the partnership position upon such event and to allow contractual continuity where possible. The clause on liability after withdrawal ensures that a retiring partner remains liable for obligation incurred before they exit. This directly aligned with Section 19 Clause 2, was drafted to protect third parties dealing with the Partnership Act. Finally, the restriction on transfer of partnership interest reflects Section 33, which limit the right of the third party assignee. The purpose is to prevent outsiders from interfering in partnership management. In conclusion, these clauses were drafted to comply with the Partnership Act 1961.
Assalamualaikum warahmatullahi wabarakatuh. My name is NURSYAFIQA with the matrix number 078451, and I will present about the third key clause of our agreement, which is dissolutions of the partnership, and I will highlight about the effect of the dissolution. I will mention two clauses. The first one is the distributions of the supplies. Why this clause is very necessary? Because it can ensure that after paying all the liabilities and the debt, any remaining asset will be divided fairly among the partner. So it relates to the Partnership Act 1961 under the Section 44, which governs the distributions of the profits and losses among the partner, and it applies in the dissolution phase as well. So it also specifies that open dissolutions any remaining profit or the asset should be distributed based on the partner capital contribution unless had been agreed otherwise. So this section provides the basis on how the remaining asset will be divided after liability have been settled, and it ensures the fairness in the distribution process. So our clause is consistent with the provision in the Partnership Act, which ensures that any leftover asset will be distributed based on agreed term. The second clause is continuing liabilities after dissolutions. So why this clause is necessary? Because this clause can ensure that partner will remain accountable for the obligation incurred during the partnership existence even after the partnership is dissolved. So the related to the Partnership Act is under the Section 45, because the Section 45 state that dissolutions of a partnership will not affect the right and liabilities of the partner for the transactions made before the dissolution. So the partner will remain jointly liable for any liabilities that arose while the partnership was active. This provision is essential in the Partnership Act because it can protect the creditor and ensure that the obligations are met even after the partnership ends. So our clause for the continuing liabilities after dissolution is aligned with the Act provisions for the continuing liability. It ensures that the dissolutions does not absolve partner from the responsibility for the past debt and the obligation.
My name is MARMAFITTY Martin. The first one challenge in this partnership agreement is aligning different opinions and expectations among partners. Each member had their own views on profit sharing, decision making, authority and roles within the business. Reaching a consensus required multiple discussion and compromise to ensure the agreement remained fair and practical for all partners. The second one is translating legal principles into clear contractual clauses. While the Partnership Act 1961 provides a legal framework, applying it into a real business scenario required careful drafting to avoid ambiguity. We had to ensure that provisions on capital contribution, management duties, admission of new partners, and dissolution were legally sound yet easy to understand.
I'm KARTIAYANY VASURAJAN. In terms of capital contribution and profit sharing, a major challenge arises because partners often contribute unequal amount of capital, skills, or effort. This can lead to disputes over how profit and losses should be shared, whether additional capital injection are required, and whether partners are allowed to withdraw their capital. Although Section 22 and 23 of Partnership Act provides the legal framework on contribution and profit sharing, practically disputes may still occur if these matters are not clearly documented. Another key challenge in partnership is decision-making deadlock. This occurs when partners have equal voting rights and unable to reach agreement, particularly on major business decisions. Legally, Section 24 of Partnership Act provides that all partners have equal rights in the management of the partnership unless otherwise agreed, which increase the risk of stalemate.
Hi, my name is SIDNEY ANAK TUGAH with metric number 078602. So today I will briefly explain the key lessons from our partnership agreement under Malaysia Partnership Act 1961. Our bakery business showed that clear terms are essential to prevent disputes, and by defining roles, contributions, and exit strategies early, the partnership can operate smoothly and promote effective teamwork. Legally, a well-drafted agreement allows partners to override the default rules in the Act, such as equal profit sharing under Section 26, by settling customized ratio like the 14 to 17% allocations in our partnership agreement. The Act also places fiduciary duties on partnership under Section 30 Clauses 1, requiring loyalty, transparency, and prohibiting competing business without consent. Our dispute resolution structure, starting with amicable discussion, followed by mediations, and then arbitrations under the Arbitrations Act 2005, which ensures conflicts are resolved without interrupting operations. From a teamwork perspective, assigning tasks based on strengths, such as drafting, research, finance, or baking, mirrors real business practice. Monthly meetings, majority voting, and defining partners types help maintain accountability and reduce free riding. Finally, we included clear procedures for admitting new partners, withdrawal notices, dissolution steps, and maintaining transparent books. These practical safeguards shows that proactive documentations support both legal compliance and long-term collaboration success.
Hi everyone, my name is AISHAH binti Muhammad ZAKI, and I am one of the partners involved in preparing the partnership agreement for the Daydream Bakery & Co. The Daydream Bakery is established to operate a bakery business focusing on the production, sale and distribution of bakery products such as bread, pastry and cakes. My role in this project was business and operational management, where I contribute to planning the day-to-day operation, defining management roles, and ensuring the business can operate efficiently and systematically. Through this partnership agreement, we clearly outline operational authority, partner responsibilities, and governance structure to support smooth management and long-term sustainability of the business. Overall, this project provided valuable experience in understanding how business operation must align with legal requirements in a partnership. One improvement we identified is the need for better time management, as some parts of the agreement required last-minute adjustment. Earlier planning would improve efficiency. Secondly, clear coordination among group members would help ensure consistency across different sections of the agreement. From an operational perspective, we learned the importance of clearly defining authority and responsibilities to avoid future conflicts. In conclusion, this project strengthened our teamwork and enhanced our understanding of managing a business within a legal framework.